Remember when we started zooming in on challenges faced by marginalized industries? The security industry's glaring inequality was one area of focus. This industry is one of the largest employers of entry-level jobs for South Africans and employs over 540,000 employees, which a vast majority being between the ages of 18 to 40. Although it being one of the biggest, with over 11,000 registered security companies, there is unrelenting proliferation of non-compliant and unregistered security providers who puts the industry in a very bad light. But what exacerbates this is how it is a grudge purchase commodity with an increasing tendency for consumers to make use of non-compliant service providers who tend to undercut the market and pay below the statutory levels of remuneration. The issue of non-compliance has led to various divisions and torn the industry apart with various interpretations on how overall compliance is viewed and applied. So we are joined by the National Coordinator of the biggest union in the private security industry, GAU, which stands for Gumwini Amalgamated Workers Union, Comrade Khumbulani Moyo. Welcome to our podcast. Continue.
Thank you for the opportunity and welcome the invite for your program.
Thank you very much, Kokeli. Kokeli, being one of the biggest union in the industry, there is a series of challenges that exist in this industry. And one of those that are very clear is the issue of non-compliance. Can we, for a person that is not part of this industry, can we just unpack the issue of non-compliance and what it really does mean? What is non-compliance in the industry? What are we talking about?
Once again, and thank you for the opportunity, and also to your viewers and to the ones that follow your program. When we come to the issue of non-compliance, it's quite one of the big cancer. We call it a cancer in terms of how it affects and has an impact when it comes to the security officers that are working in the sector. One of the major non-compliance by the companies that are within the sector is the issues of the contributions towards the Provident Fund.
Okay.
And then there's also an issue of non-contribution towards the medical insurance. And then there's also some employers who are found not registering employees with the UIF. So this comes from different spheres, but the one that is blaring, that is more of critical, that goes with workers within the industry, is the one that involves the Provident Fund. You'll find that most of these companies, they do get some work or some tender or some contracts with different service providers. But at some stage, they tend not to register employees with the Provident Fund, and then which leads to workers working for a number of years for certain companies, and then they discover at a later stage that they are not registered. Then it's got a replica effect. One is that if an employee is not registered with the Provident Fund, in case that employee gets dismissed, retires, retrenched, then he does not qualify to be able to be compensated in terms of his social benefits, because it's more of a social benefit that assists workers in times of difficult times. Before the new Revenue Act that has been signed by the President in end of May, it was more of when you retire or when you get retrenched. But as we move to the 1st of September, with this new thing that is called two-pot, it's going to have a big replica effect to the workers, because workers are not going to be able to access the amounts which they might want while they're still working. So it's one of the impact that might come 1st September 2024. But when you look at it as it is, as we speak in this your program today, is that if, for example, you're not registered with the Provident Fund and your employer is not compliant, then you are not able to access the money for your funeral benefits, which leads to you not being able to bury your own immediate family, your wife and your kids. And then secondly, when you also yourself, you pass on as an employee who is working in the sector, you'll be not covered. So you can't get your social benefit of your death benefit.
So I wanted to actually dwell on the effect of what we're actually talking about with regards to families, the impact the issue of non-compliance has with regards to your family. As a worker, if you are not able to actually get your benefits and you pass on, as an example, have you had an engagement with families that have become affected by this particular practice in the industry?
Yes, we have, as you know, that we represent next to 65,000 in the private security sector. Some of the major companies and some of the smallest companies that we have in our books as our members. So we've had such. And when they come to us, there are a lot of channels that we do follow. The first channel would be to try and contact the company and check either these employees registered. And in most of those employees or the families that come in when a member is passed on, you'll find that they were not registered. Then it becomes a more of a litigation issue where we have got to litigate against employers in terms of the requirement. Because also you will recall when the fund was established in 2001, it was meant also to give social benefits to the workers. And the fund is also not a negotiated fund where you get to a company as a security officer, then you negotiate with the employer to require that social benefit. It's a compulsory and mandatory fund. So once you work in the private security sector, it's a must. Or
That the employer must contribute.
Yeah, that the employer must contribute.
Yes.
So now the employer becomes liable in terms of if a member passes on, and then you find that also the employer cannot be able to, the family cannot be able to withdraw or to get the social benefits. So the FSCA has now amended the Act. So in most of the time, yes, we do chase the employers where you find that they are not able to compensate because the employees were not registered, because we just go to the Act and explain and inform the employer that you are liable for that cost. But sometimes it's difficult, especially when it comes to some of these small companies and non-compliant companies, because at that stage you might find also they don't have the amounts to compensate. So it becomes a dire situation where you are not able to bury even your loved one who was working in the private security sector on the basis that the employer had not registered the employee with the Provident Fund.
So what assistance is there in an eventuality that you find that an employee passed on and there is no way that the person can be able to get those particular benefits? What recourse is there besides the issue of chasing the employer? From a family perspective, is there some assistance that comes to the fore in your role as sitting in the Provident Fund?
Yeah, over and above, remember some of us were deployed there as trustees on the fund, but over and above we are representatives of the workers in general. So the recourse is there. It's only that workers sometimes they don't take advantages of it and use it. The first with the recourse is that if they are our members or they are not our members and they faced such in the past 12 months, 24 months, they are able to contact us, we can assist them. The first recourse is for them to approach the fund and say, my mother or my husband has passed on, and then we have contacted the company, and the company seems like it's not coming forward and coming forth in terms of giving us where should we go. Then as the fund, through our administrator, we are able to assist to track that employer and inform that employer that they are liable. If they don't, then we are able also to assist the family, taking the matter to High Court so that we can chase the director, the company on its own registration, and also the directors themselves who are owners of that company to make sure that the family gets compensated. Then if we don't get joy, or if they're not happy to come to us, they can also approach the OPFA, the Pension Fund Adjudicator, and raise that matter there and say, we've got this challenge. The Provident Fund is not able to pay us what we are supposed to get. and our father was working in this company, and then they named the OPFA will come up with a determination that will compare both the fund and both the employer to make sure that they pay that individual. But also, what we asking from the employees or the security officers that are following this program is that they need to be proactive. They don't have to wait for that circumstance to happen. They can contact the unions that are within the private security sector, and ourselves also were the union that is there. And then also now the good part, there's been a bargaining council in the past 4 years. There are inspectors there, which we call them agencies, that are dealing with compliance and non-compliance. They can approach them. They've got offices across the country and report those matters so that we deal with those matters while at least there are no incidents like a passing on or dismissal and all that, so that we are able to assist. So there are a lot of recourse that needs to follow. But while it's still there are some companies that have registered employees, but they are deducting and not forwarding the money. So you classify them in differently. Then those, we call them the fraudster companies, because they are deducting monies and not forwarding them. It's a criminal case which we can open for fraud, which they are a fraud and theft, which means they are deducting monies and keeping it to themselves and not forwarding it. And then there are companies that are not registered totally, which is a different altogether. But all of them, they are treated equally in terms of the requirements of the law.
From a statistics point of view, in terms of, let's just talk about the retirement benefit, actually, before we move to another benefit that exists in the industry. From a statistic point of view, per month, with regards to your provident fund, such cases, how many cases do you actually deal with on a monthly basis on average?
On average, currently as we sit as the states of the last financial year, which means on monthly basis, which is not a small number, on monthly basis, we encounter next to about 100 to 110 death benefits. So that's what we encounter. So out of that, you might find that maybe 60% of them, companies are compliant. 40%, the companies, they're not compliant. That's the death benefit. Then from the withdrawal one, you would know that there's a lot of turnover in the industry. Some contracts come to an end, some get terminated, they are also dismissal. We're looking at an average of about 1,500 to 2,000 on a monthly basis of withdrawals. But on the death one, which is quite a huge number, it's more than hundreds, because it might be your spouse, it might be your kids, it might be your wife, which are all covered in terms of our retirement fund, which has got that portion of the provident fund withdrawal.
So in layman terms, Dr. Moyo, you're saying that a person who works for years,
yes,
and they pass on with nothing. In layman terms, you're saying that a person is employed by a particular company for years, they retire, and they get nothing.
Yeah, I think in terms of your expression, that's correct. And also, if employees are not conscious, because employees need to be alert and make sure that if you see yourself as a security officer, anywhere in the country, in all the 9 provinces, you might be in bigger cities or smaller cities, you need to be registered. It's law. It's not a negotiation. So in layman's terms, if you are not registered, you can work for 10 years, 20 years, or 25 years maximum, because you start roughly in the security sector. If you are 20 or 18, you can work for all those number of years. If you don't see it in your pay slip being deducted, and if you don't receive your annual benefit statement every year, there is a question mark that you must ask your employer, or ask your representative, your union, or yourself. You can approach the administrator of the Provident Fund, or any offices that deals with the private security sector. Like I've said, now there's a bargaining council, and double check whether am I registered. You don't stop there. If you are registered, also you must check either your employer is compliant, and then that information is easily available. They'll just put your ID number, your full names and surname, and check and tell you. If your employer is owing, they will also tell you that no, your employer is owing, is not contributing. Because remember, in terms of the law, employers need to contribute to the fund on or before the 7th of each month. and they need what we call schedules, which is your name, your surname, and the amount that they have contributed on or before the 15th. So if that is not happening, it's a red flag on its own.
So the ones that are deducting monies
Yes.
and not paying it over, when you engage those companies, I'm sure as a representative of the Provident Fund and sitting there as a trustee, but also you're wearing a cap of representing workers' interests and being one of the biggest unions. So when you engage with those companies that are deducting monies and not paying it over to the fund, what is the discussion? What is the merit of a discussion that you normally have? What happens there when you negotiate with them?
No. The other issue is that there mustn't be negotiations. It's law. So you can't negotiate on behalf of the Provident Fund, or you can't negotiate on something that is written in law. So there's no negotiation there. So the requirement is that they need to comply. And over and above, if they don't, and if we pick it up that they don't, because some workers might come to us, join because they've got issues in regard with the Provident Fund. So yes, formally we need to notify the employer and say one of the concerns that the workers are raising is the issue of the Provident Fund. Then we just inform the employer to comply. But also remember, in the fund space, there is an arrangement that you can make if you are willing to. It's called an AOD. It's not regulated as much, but it's something that assists in terms of making sure that those employers who might find that maybe sometimes they were struggling in terms of their understanding or submission of schedules or communication with the fund, that's the only leg that we can only assist on. But we can't negotiate on a social benefit that is lawful. So like I've said, that the good part now is that once we inform you, we pick up your company and find that you are not compliant with the Provident Fund, there's only one way, it's to take you to jail. Because in terms of the FSCA, there are only two fines. The first fine is that if you are found that you're not in compliance, it's a 10 million fine, either regardless you're owing 5 rand or 10,000 or 20,000 or 200,000. That's the fine if you're found guilty. Or 10 years in prison. So now, or both, which means you can pay a 10 million fine or also be incarcerated for 10 years.
Has there been employers that have gone through the legal system with regards to them fraudulently, deducting monies and not paying it over? Has been that process undertaken before?
Currently, we're sitting from the fund side because there was an amendment of law in terms of the FCA. Because remember, previously, people would register companies and not attach themselves. So it was difficult. A person will come in, liquidate his company, leave, but the director goes and opens and starting your company on a different name. Yes. So now you can't run. Now we can chase you with your ID and your registration is CIPRO. If we don't, you find that you have liquidated, we chase you as an individual. There is a case that we did in Bethlehem. This employer in the Bethlehem Magistrate Court in in Bethlehem Magistrate Court, this employer was owing over 300,000. And then he was supposed to be incarcerated for that particular years. Then he ended up agreeing to pay that 300,000. There is one current case that is going on in Kimberley with one company. I'm not quite sure whether I'm allowed to name them in your show. I don't mind you too. It is one that currently we're busy with. Yes. It's a company in Kimberley that was deducting and not forwarding. That company. The Hawks have assisted us. The NPA is involved in that case, which soon there will be a judgment. Then there are cases, we've got 40 companies from the fund side that are at High Court. Most of them, they are big companies. Some of are well known, which we're dealing with at High Court. Over and above, there is a route now that has been opened by the pension fund adjudicator. We have submitted 20 cases to her in terms of they're trying also to assist in adjudicating. So there's a lot that is happening, and soon most of these cases will be finalized and the examples will be set for those directors.
Interesting. So let's move over to the medical benefit.
Yes.
I know that the issue of the medical benefit, it is a negotiated benefit that happened on these past wage negotiations that actually took place. and that came into effect. So the implication there in terms of also those employers that do not pay towards that particular contribution, when it comes to a worker perspective, what is it?
Yeah, that one it's a bad, it's even, we can't even quantify it. Because when you look at the medical insurance benefit, the trade unions in 2006, when there was a major strike in South Africa, I think 27 security officers passed on and died fighting for that benefit. Then it came into the fore in 2021, where we finally agreed, the employers implemented it. But it comes from a big research that we've done as a sector to find that, for example, if you have never been a security officer, I've been a security officer before, you find that you are working a 12-hour shift and then you work more than 21 days in a month, which we call shifts in the sector. And then some their day shifts, which is a 12-hour, and then a night shift, which is a 12-hour. Over and above, you are faced with maybe a medical challenge or medical condition. You need to go to the hospital or to approach private doctors to deal with certain medical conditions that you might be facing. Then you find that it was a challenge to security officers, which some of them even died of diseases that could be cured because they couldn't access medical assistance. Because, for example, if you go to a hospital or a clinic, you have got to queue. You must wake up at 3 o'clock to get there. But where will the security officer get that chance?
Because of their working conditions. Yes.
So we agreed through the mandate of the workers that there must be such benefit, which is quite good for the workers because now they are using more of private doctors, which similar to a medical aid, but at an affordable price. So it also improves the working conditions of the employees. And now, because in the last negotiation, we even included their families, because previously it was only a worker. Now they are able to aid even their families, their spouse or their husband or their kids. And then they are able to have that social benefit, which is good for the industry. And then also when you look, one of the research, when we're doing the research early in the 2005 and 2004, there were chronic diseases such as TB, which we found that 30 or 40% of the majority of workers in the private security sector, they get affected on those. And those are curable diseases. Those can be treated. But for them to get knowledge and assistance, it couldn't. And then also with the one that involves the HIV and others, where you are able also to get chronic. But for you, during that particular time, even nowadays, for you to get to the queue where you are able to get medication, it takes time. And by that time, someone would have passed on. So some of those 25 chronic medical benefit diseases that are covered by the medical insurances, they are covered. It's mandatory. So in the past 3 years, we have seen that the health of our security officers in the industry, especially those that belong to the medical insurance, they've been assisted because they are able to collect your medical chronic diseases from Discam or from ShopRite, Medirite, and some of these pharmacies, which you get through the medical insurance that is there. And over and above, you get over-counter medicine, where you don't have to go to a clinic and wait. So which is quite a social benefit that is assisting. And there are a lot of benefits that come with the medical insurance. But we know that some companies, as we discussed on the other issue of the retirement, some companies are taking advantage. They're even deducting currently and not forwarding it, and using it for their own benefits, which already the Bargaining Council, because it's the custodian to enforce, they've enforced a lot of cases on those and made sure that those directors are taken to task. As much as it's still new, it's next to 3 years now, being functional on the medical insurance. But also the employers can confirm now that the attendance and the happiness and the spirit of their workers has improved.
Has improved so as a result of this benefit, yes.
Yeah, because the numbers from when it started, now they are sitting in over 300,000 security officers that are covered. Compared to your figures that you had raised of 550. There's still a long way to go, which other companies also still need to register their employees in that scheme, because it's going to be compulsory. It's a compulsory medical insurance for the industry, which we encourage all security officers to be alert because it's their social benefit. If they don't raise that our employer is not deducting, then we are not going to know as the unions. And also the Bar and Council is not going to be out.
So now let's go to the UIF.
Yeah.
What are the issues with regards to the UIF benefits in particular?
There's quite a lot. We've engaged the Department of Labor. The Department of Labor, their own challenge is the number of the inspectors. I think you have heard. They're sitting with less than 2,000 inspectors across the country, which is a big challenge. And their enforcement, also we've raised concern, we've engaged with them. They're a key stakeholder, but we've got a lot of concern. We know that they've moved some of the contributions towards SARS and other systems. But also, when you go to their database, most of the time they don't pick up the schedules. Schedules are critical because once you pay, either it's R5 or it's $1 million towards your employees, towards the contributions of the UIF. The UIF needs to allocate. It needs to know whose money is it, where is it from. So that's one of the challenges that we have. Then we have got the waste one, which we get on monthly basis, maybe five complaints or 10 complaints or 20 complaints. The issue of the maternity benefit
Tell me more.
of women who are going for maternity. Because remember, when you're going on maternity, there's a UIF benefit that you must get, the maternity leave payment that is supposed to be paid by the Department of Labor. But when workers go there, especially the women ones, who have given birth or who are about to give birth, they find that they're not registered. They're not paid on the system. So we've heard those complaints, and the Department of Labor continues saying, no, you must use it. Yes, we understand that there's now technology, but technology cannot come at a disadvantage of the working class because they are the key contributors towards that fund. So you will find that women, they even give birth, ended up going back to work without receiving the payment from the UIF. It's a big concern, which we have raised also with the UIF to say, can they address that? Because they are the custodian of the UIF in the entire country. It can't be the Bar and Council. It can't be our inspectors from the Bar and Council, for example, of the private security sector. They own that right to make sure that they enforce. So, and also, the other one is when employees get retrenched and get dismissed. They are supposed also to be able to be compensated because UIF in its summary is an acronym. It's Unemployment Insurance Benefit. So it needs to benefit employees when they are retrenched, when they are dismissed, or when they don't have work. And the one that we're going to challenge in this 7th administration is the one which they put in their document. When an employee maybe decides not to come to work of certain reasons, you know that employers are naughty. So when the employers are naughty, they will say absconsion. So when they complete that form, they'll say absconsion. Then that employee, he cannot be able to access the benefits of the UIF because there's an absconsion. And they don't go into detail to state why it led to this employee to be absconded. We want that to be scrapped so that employees are able to benefit because it's a decision that is taken by the employer. And when he completes the form, because the employer has got an advantage to complete the form, he just write absconsion. And when it says absconsion, that employee cannot be entitled to get benefits from the UIF benefits. And the other one is a retirement. It is a resignation. There are a lot of reasons that lead employees to resignation, but it's in their forms, and this is disadvantaging workers. And when you Google today and check, how much does this fund have? It's got trillions, and that is money for workers. It's not theirs. So we are saying that those two, we need to challenge it neglect and say we are not happy with these two clauses because a person may resign because of health conditions, because of being victimized, especially when it comes to women. There's a lot of victimization. Then a person decides to resign because he feels that he cannot continue in a toxic environment or in a workplace where there are no workers' rights. But that employee is disadvantaged on the basis that he has resigned. And the Department of Labor, when they came with that, we thought maybe they are saying because I'm resigning because I've got another job. But you would know that the unemployment rate in South Africa currently is sitting around 42%.
Yes.
There's no one who can just resign because he likes resigning and going. But because if you resign and go to another company, you'll be picked up because the UIF uses an ID number to identify people. So we're saying it's a big concern. But over and above, it's the non-compliance of the workers to register employees with the UIF.
So the scourge of non-compliance in the private security industry, it's one of the glaring issue that for years organized labor has tried to actually pick up and decisively deal with. There are instruments in the private security industry that are there to actually monitor that at least there is some level of compliance in the industry. How effective are these instruments that have been put in place?
Yeah, it's difficult to say they are effective, but we can measure. We can measure in terms of how the organized labor in the past 2 years, which I can say, they have come to the fore to participate that. And as TAO, I think we've been involved in most of them. And also with the other 4 unions, which is SATAO and Dabangobi and Sansof and NOMSA. We have also tried to come in and say it's part of our role, because in terms of registration of the unions, it's part of their role to deal with and report the non-compliance. We can say we've made some strides, but not as much as we expect. We know that we went to Mpumalanga to the Premier's office to hand over a memorandum, which was received. There has been elections recently. We know that we're going to do a follow-up again to get a feedback. But before the elections, we went also to the Eastern Cape, to the Premier of Eastern Cape. They received as well. There were about 760 companies there. 500 of them, they were non-compliant. But the Premier has sent notices.
Is this in the Eastern Cape?
In the Eastern Cape, yes. The Premier has sent letters through their supply chain to demand all the requirement compliance documents, which we have seen most of the companies coming to the fore, making sure that they want to comply with the medical insurance, with the Provident Fund, with the UIF, because they need all those documents from the relevant stakeholders. So which we feel that is a welcome move from the Premier in Eastern Cape in intervening that. And also they've undertaken that any company, they are going to give contracts. They are going to pay in line with the prescribed rates, because some companies, they will come in there and say, I can provide a security officer for 12,000 or 13,000, and you find that the prescribed or illustrated rates, they're even far below that.
But that's what I wanted to actually come to, that, most of the employers that you find in the private security industry, and especially perhaps maybe your small and medium enterprises would indicate that they render services to government and other state entities. And you find that government works on the lowest bidder principle, right? And for you as a startup, you get an opportunity, you tender, and because you want to compete, you decide that you're going to go lower than the illustrated pricing guidelines that do exist in the private security industry. So now, and then you decide to go lower, but you expect it now to actually comply with various benefits and contribute. So how do you now work with that disparity? Because then a person will send you back as organized labor to the consumer and say, isn't it that it's the consumer that is supposed to be the one that is actually giving fair, what do you call it, pricing? In terms of being able to get the necessary services that they're actually procuring. How do we now work with that disparity?
Yeah, well, that's why we, as the organized labor, over and above, because we don't have boundaries as organized labor.
Sure.
So we've started that struggle to conscientize and advise all government departments, especially those who are doing work at government departments. Last year, we had a meeting with Department of Agriculture, their head office. The glaring and surprising thing, the same concept that you have said, that they give the lowest bidder based on, in their department, like enough, the Director General there invited the supply chain and said, this is the bargaining council, and these are the organized labor, because there was a particular company that said, guys, this is what they're paying me. shop steward, this is what they are paying me. Union, this is what they are paying me. Where do you expect me to get? Because there are issues like annual bonuses that you need to pay, which are compulsory. Because this industry is regulated. For years, we've fought for it to make sure that it improves the benefits of the workers. So what we picked up was that even the supply chain, they don't understand the illustrated values that are in the bargaining council or within the CIRA website that shows that at least this is what the service provider need to quote you on. So that has been corrected. And then secondly, we've approached Treasury, which is a big procurer of all security companies.
Yes.
We've given them their rates. They've acknowledged that they will work moving forward with the bargaining council, making sure that the updated list, updated rates, they are available so that when they go to their supply chain, at least they've got a benchmark to say if Moyo Security comes here and says they are going to offer us a security guard for 12,000 or for 10,000, we are not going to accept because we know they're not going to comply with all the regulatory requirements that will make sure that the lives of the security officers are improved.
So how do we deal as an industry with unregistered companies? There's a lot of them that are actually operating all over. You know, they tend to even employ security officers that are unregistered. And that actually leads to a whole of proliferation of crime because that has got an effect as well with regards to a consumer employing a service provider that is not registered, that is not appearing anywhere and has got security companies. What is your view with regards to that? Because there's a lot of unregistered security providers in this country. What is the effect of that in the industry?
Yeah, there are underlying issues, but over and above what we have said as organized labor is that all key stakeholders need to play their role. We've got a stakeholder called the regulator, which is CIRA. They must be in that space. And we have asked them several times that let's collaborate. But I might say that the director there is engaged that he's going to allow us to collaborate with all stakeholders and deal with non-compliance. But remember, in South African law and in terms of the CIRA regulation, a person cannot operate any service in regard to security, being a security service provider without being registered. It's illegal. You can be imprisoned for that. Then second, you cannot employ people who are not registered. That space for, we can say these are South Africans who are working here. If you're a South African, you want to open a company, you must register with CIRA. They must check whether you don't have a criminal record, because now we are looking after assets of people, when government assets in role. Then as an individual, you need also to be registered. They check your criminal records. That's CIRA's work that they need to do. Then, like you have said, that there's a lot of companies that are not registered. Those in our sector, we call them fly-by-night.
Yes, fly-by-night.
So those fly-by-nights, now they've came up with a lot of unwanted things within the private security sector. One is they are employing foreigners. Foreigners can work in any other sector, but in the private security sector, unfortunately, they can't work. That's a law. And two, if you're a company owner, if you're a foreigner, you're not allowed. That has been gazetted and stipulated. Security companies must be owned by South Africans, and also the people who work there as South African. So if you go in other areas, which I can't mention, but some I can mention, if you go to Foxburg, China Seat and all that, you'll find that there's a lot of illegals working there. And they call themselves security office. It brings a big risk to the South African security, because some of them you'll find they're carrying firearms and they are not locals. So there are a lot of companies that we know which were violated and fled to CIRA to say, go and investigate. Some of these people, they're not supposed to be working. They can work in other sectors, either in the restaurants and what, but in the private security sector, it's regulated because some people that are deployed in national key points, like the SABC at the airport and all that. So security checks are critical from the owner of that security company and also the employees that are working. So if those who are listening to your show are following, they need to raise that. As a whistleblower, They can go to the council, they can go to CIRA and raise that. I know CIRA is doing a great work. There's a lot of investigation that they are doing, and especially nowadays, they've put a lot of intelligence when they're investigating those companies. So that's one of the requirements that we applaud from CIRA, that they've came up with a lot of strategies to deal with. But it's still there. But we're saying people must continue, especially those in the private security sector, to highlight and report.
So the people that are employing illegal immigrants and stuff, the impact of it in terms of the private security industry, it indicated that by law it's not allowed.
Yes.
That's one.
Yes.
But what is the implication, the ramification of that?
It's some of the issues that we've been speaking about. Because these people, they come in, they do we call it in slang, undercutting the market, which means they charge half of the price. Because the people that are working for them, they will pay them up to nothing.
Peanuts.
Yeah.
Yes.
Yeah, it's called.
Yes, they pay them peanuts.
Yeah. So that's the ramification. Then also, when it comes to compliance, then the compliance goes down. Because you'll see a security officer and think he's compliant, but it's not. But also the amendment of the Labor Relations Act, especially if an employee comes to us and opens a case, it says, now if all the service providers are liable, which means we can summon, for example, yourself, if you are the procurer, and summon the company and the employee to come and answer, to say why the three of you are not complying with the industry requirements. You know, so we can do that. So if we get those reports, we can prosecute you. And you as a service provider, as a service procurer, you know, a client, you can also be procured.
So a client can be held liable?
Yes.
Okay,
Yes.
okay.
Can be held liable in terms of the amendment of the main collective agreement of the private security sector. So we are allowed to call you and say, come in and answer, why are you paying this person like this? Do you know what the law says when you procure a security office? Because at the end of the day, we must look at the interest of the security office, not of the company. But the employee finds himself at the last end, because there's a client, then there's a client, there's a service provider, then an employee becomes number 3, and it suffers because you find that the service provider is not able to pay the employee. But you would know that there's that law of confidentiality. But when it comes to us, we use Section 16 of the Labor Relations Act to disclose information, and someone, the 3 of them, so that we look at the welfare of the employee.
So let's look at the industry, its future going forward. It's a parting shot. Because, you know, now that we're running a series with regards to the private security and its challenges, they seem to be ongoing. And I know that you said that there's measures in place that have been put, the structures in place that have been put. There's governance as well that is taking place with regards to shaping the landscape of the industry. As a main contributor to the GDP, you know that the industry, I mean, we contribute a lot of money within the GDP. Where do you see its future going forward?
If all stakeholders come together, there's a bright future. If I talk of stakeholders, I'm talking of the regulator, which is CIRA. Then I'm talking of the Bargaining Council, which is the enforcer currently in terms of some of the main collective agreement. Then I talk of the organized employers. We know we've got SANSIA, which is the biggest organized employer where the employers belong to. Then we've got SANSIA. Yeah, we've got SANSIA and SANSA. And then we've got also TAPSOSA, which are the biggest employers. So we are saying, and also we've got organized labor, which is ourselves, which is like the trade unions. We are saying we need to get into a boardroom and box each other and iron out the differences, and also bring in also the Provident Fund with their trustees or through their chairpersons and on, and sit in one room and say, how do we want to see this industry in the next coming 5 years? And then what is it that we need to develop and work together? Then we know that the biggest procurer is the government. Yes, we've got the private companies, private organization that procure security. But we know that government procures a lot of the private security sector, which also we've started engagement. Also in that endeavor, they must come in and elaborate and try and understand the challenges that the industry is facing. From there on, we can work together on the benefit of the security officers. Because if you look now, CIRA on their own database, the active members, they're sitting at 1 million. And then the current working, in terms of your figures that you've picked up, I don't know where you picked them up from, but you're saying they are over 500,000. And then when you look, for example, if we use your figures of 500,000, if you were to come in and say, okay, Bowen and Council, can you give us your figures? How many employees are registered? There's less than 300,000 which are registered.
That are registered with the Bowen and Council.
If you compare the 1 million and your 550 which are active, you see there's a lot of gap. Then if you go to the medical insurance, there's 320,000 that are registered.
So the but it's 200 and something thousand that are not participating.
So if you go to the Provident Fund, we're sitting less than 270. So you will see that 550,000, we were not even there, which means the 200 and something thousand, like you are saying, they are not registered with the Provident Fund, the medical insurance. Most probably, I know we might have higher figures at the UIF because it's one of the quicker requirements. But I'm saying if all these stakeholders sit together, we might improve the working conditions of the workers. But over and above, if you look at the organized labor, because I know that there's a lot of negativity of workers joining the unions, but I'm saying it's the right time now where they should come in and assist because all the benefits are there. It's not a matter of that I've joined this union is not assisting. It's upon them because workers need to start to be active so that they get this benefit. Because when you look at the organized labor in terms of the 2023 statistics, they will tell you that there's less than 170,000 who belong to unions. So which is less 23% or 24, next to 27% of the workers that are organized in the private security sectors. Yeah, but although the employers, in terms of their numbers, they're sitting more than 50, I think minus 27, next to 63% of them having people who are working in their sector. So there's a lot of a gap, and it should be the other way around. It should be workers who are belonging to unions 63%, and then workers that are registered with employers 27%. But we are saying also it's more of an activism, and also unions being visible and accessible to members, and being true to the fight of the workers' plight. Because yes, we know that workers sometimes just disgruntled with how unions operate. But my starting point for them through your program is that they must make sure that they belong to the unions. But I'll also further on and say they must belong to unions that are within the Parliament Council, which are around 8 of them. They can join others, but those they would understand the plight better than any other union that is not in the sector.
Dr. Mayo, on that note, thank you for joining us. There are certain issues as well that I think that we actually need to pick up. I'm hoping in the industry itself, I'm hoping that, we are not going to end in terms of this particular conversation on benefits that are not actually derived by workers in the industry. There's a whole lot more that is happening, and there's a lot of education, information, and an awareness that has to come to the fore with regards to the industry itself. And I'm glad that there is individuals such as yourselves that are coming up and are saying that, let's stand together and be able to actually see this industry moving forward. And in that case, I am very thankful for you coming through to participate in this podcast, and I'm hoping that in future we can be able to have further discussions on other issues. Thank you very much for coming through.
Yeah, no, we thank you for your opportunity. I think we'll come soon and deal with the two-pot system.
Yes.
Because the workers, they need to understand what will happen on the 1st of September. So, but thank you for the opportunity, and we thank your viewers for following you. We encourage them to follow the program. I think you're doing great work. What do you call it? Forum for Marginalised Industries.
Yes.
Yeah, we're one of them.
Yes, thank you very much. Thank you. Thank you.